Executors cannot do things which are contrary to the benefit of heirs, beneficiaries, and the estate. This means if you suspect an executor is withholding your inheritance distributions, you have the right to sue the estate or litigate to suspend, remove, or replace the executor. What is an executor of a will or an administrator of an estate? The executor of a will or administrator of an estate is the individual responsible for handling and completing the probate process for the decedent's estate. Commonly, a parent may name their oldest or most responsible child as the executor of their last will and testament. As such, it's that child's responsibility to handle the estate's probate process, including paying debts, using those estate assets, selling estate property, and distributing assets to heirs and beneficiaries according to the last will and testament. What are the executor's responsibilities to beneficiaries? Being named the executor of a will brings with it a wide variety of important duties that must be carried out to meet the wishes of the decedent. If you've been named as an executor, here are several of the functions you may need to undertake. Number 1, locate the will. 2, retain an attorney to help you with the probate process. Number 3, identify and protect the deceased person's assets. Number 4, review the will and keep its beneficiaries informed. Number 5, notify all other appropriate parties. Number 6, continue paying bills as needed. Number 7, start distributing assets of the estate to the intended beneficiaries. And number 8, file the papers to close out the estate. Can an executor also be a beneficiary? The short answer is yes. It's quite common for an executor to also be a beneficiary. Consider when one spouse passes away. The living spouse of the decedent is frequently named the executor. It's also common for children to be named both beneficiaries and executors of wills or trustees of a family trust. Is it true that an executor cannot be a family member or friend? That's false. An executor often is a family member or a family friend. In many cases, we see parents name their spouses or children as executors, and we also see children naming parents or siblings as their executors. In some cases, as estates grow in complexity, we see trusted family friends, often professionals in one capacity or another, being named as executor. Why? Well, the principals of those estates often feel that a family friend is the most experienced, either with the estate planning or administration process. They're the most capable to deal with those more complicated estate assets or perhaps family dynamics, or they're the person who has the time to handle the probate process in the event of the parent's death. For example, a parent's estate that's valued at, say, $3 million and includes 3 real estate properties and a small business. In that kind of case, the parent may choose to name a trusted family friend, perhaps a business partner, as executor. Because that family friend is a professional who's familiar with the business, has the time to handle the business's affairs and the experience to handle those affairs, as opposed to the children who may be working full-time in their own businesses, taking care of their own families, etc. In these cases, the parents feel that their estate's in good hands, and the children can often appreciate that someone other than themselves was chosen so that they don't feel forced to spend time on their parents' affairs. What if the beneficiaries cannot find or locate an executor of a will? Well, if the beneficiaries and heirs of an estate cannot locate the executor of an estate, or if the executor has passed, then the local probate court will appoint someone else to serve as the executor. The court will issue letters testamentary, which is the document that authorizes someone to act on behalf of and in the best interest of an estate. Please note that a living executor can also be disqualified from their role if they're incapacitated, convicted of a felony, for example, or express what the court or beneficiaries believe to be a conflict of interest, such as favoring one beneficiary over another. What if the executor cannot locate a beneficiary? If an executor cannot locate a beneficiary, then the courts will need to be convinced that the beneficiary should be deemed as though they had deceased. Before the court will do that, the executor must show and document that they've done the following. 1, that they've reached out to any and all living spouses or family members of the beneficiary. 2, sought the beneficiary's last known mailing address. 3, reached out to previous employers. 4, reached out to other individuals in the community. 5, often you'll have to engage someone, perhaps a private investigator, to do the work to try to find the person and prove to the court that the person cannot be found. It can be a laborious and sometimes expensive process that takes a significant amount of time. If you're unable to find a beneficiary after a certain amount of time and you've demonstrated that you're unable to find them, then the missing beneficiary will be treated as if they had predeceased, and their inheritance and assets will be distributed to other family members, heirs, beneficiaries, pursuant to the will, if there is one, or pursuant to the probate code in that state. Does an executor inherit something if the first choice or primary beneficiary cannot? Firstly, the role of executor is that of fiduciary, not beneficiary, and as such, the executor is only entitled to the executor fee, not an inheritance. The executor fee includes the legal right to be paid by the estate for their time and effort. This amount is dictated by state probate code and is coincidentally the same amount paid to a probate attorney who's administering the estate with the executor. For example, in California, the executor of a $1 million estate is entitled to be paid $23,000 for their time and effort. In addition to their statutory fee, that $23,000, an executor may also be entitled to recover what's called extraordinary executor fees for services that are not a normal part of an administration. Some examples include selling real property like the family home, running a business, or handling litigation on behalf of the estate. Secondly, if the executor is also a beneficiary, then they are entitled to their inheritance distribution as dictated by the will, trust, or state intestacy law, just like any other beneficiary. Plus, they are also entitled to be paid for their time and effort serving as executor. At RMO, we see many executors decline their executor payment when they work with a probate lawyer, and sometimes when they're not working with a probate lawyer. Why? Well, often when they're working with a probate lawyer, it's because the lawyer was handling the responsibilities. Sometimes even when they're not working with a probate lawyer, they'll waive their executor fee because they don't want to take monies that they would otherwise receive as an inheritance as income on which they have to pay taxes. And sometimes they'll just do it to be fair to their other family members and the other beneficiaries. Can an executor override a beneficiary? The executor cannot change the last will and testament. It is the executor's express duty to act in the best interest of the beneficiaries and the estate and to carry out the stated intentions of the decedent as set forth in that will and trust, including distributing inheritance assets to the intended beneficiaries and heirs as written out in that will. If an heir or beneficiary feels that the executor is not fulfilling the decedent's intent as dictated by the terms of the will, then it is the heir's right and frankly their obligation to pursue litigation against that executor to force them to distribute to them what is fair and what was intended by the decedent as written in that document. Can I sue the executor of a will or the administrator of an estate? Yes. An executor or administrator can be sued just like anyone else. However, if what you're looking to do is challenge the distributions of a will or trust, then you will need to contest the will or trust via probate or trust litigation. For example, if an heir feels that they deserve a larger inheritance than what the will or trust provides, then the heir will need to hire counsel and prepare and file a contest petition. Differently, if an heir feels they are entitled to assets from the estate not as inheritance but rather as reimbursement because they, for example, paid more of the decedent's medical bills than the other heirs and they feel that it's unfair that they haven't been paid back for those, then they may be able to seek additional monies via a creditor's claim. In any case, if you feel you deserve a larger inheritance, contact a probate litigation lawyer who can help you decide whether it's something that you should pursue. When do I contact a probate lawyer? Our best advice is that you contact a probate lawyer as soon as possible. The sooner you contact a lawyer, the more easily and sooner they can work to protect your rights and get you your rightful inheritance. Generally, it's much easier to earn your rightful inheritance through litigation before the estate assets have been distributed. Do I need a probate lawyer near me? We recommend finding an experienced probate lawyer familiar with the county probate court in the county where the decedent lived and the administration is going to take place. For example, if the decedent lived in Los Angeles, we recommend working with a probate litigation lawyer in Los Angeles. That Los Angeles probate litigation lawyer will generally be more familiar with the Los Angeles probate court division than an out-of-state or out-of-area attorney. Have questions? Give us a call, shoot us an email. We're always happy to help. At RMO, we protect people like you every day. Thanks for watching.